Criminal Court for Bravamon County, Tennessee is now in session with the Honorable Justice Campbell presiding. God save the United States, the state of Tennessee, and this honorable court.
You may be seated.
Your Honor, today's case is the state of Tennessee versus Alex Callahan, case number 25CR0344.
Okay, thank you. Good evening. We are, I think, ready to proceed. Are there any preliminary matters before we begin?
Yes, Your Honor. First, may I introduce myself?
Yes, please do.
My name is Binyam Dunn, and I, along with my co-counsel, Miss Alice Littlehale,
Good afternoon, Your Honor.
and Mr. Isaac Fulton,
Good afternoon.
represent the state in this matter. Additionally, may we introduce our witnesses?
Please do.
First, we will be calling Mr. Rory Branigan, played by Bryce Cochran.
Your Honor.
Good evening.
Then we will call Mr. Sky Gonzalez, played by Evan Giles.
Good evening, Your Honor.
Good evening.
And finally, we will call Dr. Lee Waldo, played by Caroline Stinner.
Good evening.
Your Honor, would you like me to proceed with my pretrial matters or allow the defense to introduce themselves as well?
Let's allow the defense to introduce themselves, and then we'll hear any preliminary matters.
Of course.
Thank you.
Your Honor, may I introduce myself and my co-counsel?
Please do.
Good evening, Your Honor. My name is Manhattan Thuitt. To my left is Mr. Drew Oakes.
Good afternoon, Your Honor.
Good afternoon.
To his left is Miss Libby Seago. Good afternoon, Your Honor.
Good afternoon.
We represent the defendant, Alex Callahan, in this case. With that, the defense is ready to proceed to pretrial matters.
Thank you. Let's proceed then with any preliminary matters.
Yes, Your Honor. Pursuant to Rule 33, we ask the court note that stipulations are to be entered into evidence. Would Your Honor like a copy?
Yes, please.
May I approach the bench?
Yes. Thank you. Okay. Anything
Additionally,
else?
we ask Your Honor's preference about moving about the well. Should we ask permission to approach witnesses, yourself, or the jury, or should we move freely?
If you could ask permission to approach the bench, you may move freely within reason about the well, but please be reasonable, or I will instruct you to keep it to a minimum.
Of course.
Thank
and
you.
Pursuant to Rule 13, we ask to have our own timekeeper in the jury box. And pursuant to Rule 16, we ask that all witnesses are present and not sequestered during the trial.
Any objection?
No objection, Your Honor.
Okay.
That concludes our preliminary matters. With that, the state is ready for trial.
Okay, thank you. And how are we going to proceed with respect to swearing in witnesses? Do we want to swear in each witness? Would we like to swear in everyone at once?
Your Honor, in past trials, it's been pretty common for the bailiff to swear in all witnesses at once, either before or after opening statements.
Okay. We'll proceed in that manner here. Thank you.
Your Honor, the defense has one brief preliminary matter.
Go ahead.
We would like to draw the court's attention to stipulation 10, which notes that all exhibits in this case have already been agreed upon as authentic. With that, the defense is ready to proceed to trial.
Okay. If there is nothing else, no other pretrial matters, I think we're ready to begin opening statements.
Yes, Your Honor. May I proceed?
You may.
The sponsorship, the scarf, and the signal. Remember these three words because they prove the truth. That the defendant, Alex Callahan, committed first-degree murder because of a business deal gone wrong. The sponsorship, the scarf, and the signal. First, the sponsorship. During today's trial, you'll hear that the defendant and Mr. Johnny Malone's relationship started off strong. Mr. Malone presented the defendant with a promising dog toy business idea. The defendant decided to sponsor the proposal. The product initially saw great success, however, problems quickly arose. Reports came out that Mr. Malone had concealed test reports that revealed that the product had a risk to cats. the defendant themselves will admit to you today that they pressed Mr. Malone about these reports. Instead of fessing up, Mr. Malone doubled down, claiming that the defendant had known about these risks all along. Then, Mr. Malone made it personal, claiming that the defendant's whole career was built on shady business dealings. After that argument, you'll hear that the defendant and Mr. Malone's relationship fell apart. Mr. Malone had disrespected the defendant's sponsorship, and that upset the defendant. Our first witness, Mr. Rory Branigan, will tell you just how upset the defendant was. He'll tell you that the defendant was on the warpath about this bad business deal. He'll also tell you that the defendant was dead serious about this problem. Our second witness, Mr. Sky Gonzalez, is a waiter at La Scala Restaurante, a restaurant that's just a few steps away from the scene of the crime. He'll tell you that just a few weeks prior to when Mr. Malone was killed, the defendant and Mr. Malone met up at this restaurant. He'll describe this meeting, that it was tense, uncomfortable, and at the end, the defendant stood up, scribbled an angry note, and threw it at Mr. Malone. He'll read this note out loud to you today, and it will say, "Last chance. See you soon." Throughout this trial, you will see that this failed sponsorship led the defendant to killing Mr. Johnny Malone. Second, the scarf. Mr. Gonzalez, that waiter at the restaurant, will also tell you that during this meeting, the defendant left behind a distinctly orange scarf. Mr. Gonzalez also happened to be working on the night of the murder. He'll tell you that he heard the shots that ended Mr. Malone's life. He'll also tell you that someone was seen fleeing the scene of the crime wearing a distinctly orange scarf. And third, the signal. The scarf isn't the only piece of evidence that connects the defendant to the scene of the crime. The defendant's own cell phone places them there too. Our third and final witness, Dr. Lee Waldo, is an expert in telecommunications engineering and cell phone triangulation. She'll explain to you that cell phones connect to various towers. She'll describe her analysis process and that using different maps called detail records, she was able to approximate where the defendant's phone was at the time of the murder. She will tell you with professional certainty that the defendant was within walking distance of the scene of the crime when the shots were fired. As the state, we carried the burden of proof in today's trial, but we embrace that burden. We will show you beyond any reasonable doubt that the defendant committed first-degree murder. Members of the jury, this case is simple. The defendant killed Mr. Malone. The sponsorship, the scarf, and the signal show that the defendant stopped seeing Mr. Malone as a business partner and started seeing him as a liability. At the end of today's trial, we will ask you to find the defendant guilty. Thank you.
Thank you. The defense may proceed.
Yes, Your Honor. Before I proceed, may I ask for the microphone for the opposing counsel?
Yes.
Thank you. May I proceed, Your Honor?
Please do.
There's only one thing opposing counsel is going to prove today beyond a reasonable doubt. They decided first and investigated second. You'll learn that from the very moment their lead detective heard the name Alex Callahan, he had made his decision. You'll learn that what they're calling an investigation was anything but that. It was forcing facts to fit a theory and ignoring everything else. They investigated backwards, and they got it wrong. But they arrested Alex Callahan anyway. Members of the jury, this is Alex Callahan. She's 35. She works in finance. She is not a murderer. And even though she has the constitutional right to sit right here and say nothing, she will take this stand today, look you in the eyes, and tell you she did not. She would not kill Johnny Malone. This is exactly what Ms. Callahan tried to tell law enforcement when she voluntarily went with the detective to be interviewed. She gave him records confirming she was at her place of work the night of the murder, but the detective had none of it. Instead of listening to this woman, he looked her in the eyes and told her, "You are going down for this murder." Because it didn't matter what Ms. Callahan said. The detective had made his decision. He had decided first and investigated second. Today, you won't just have to take Ms. Callahan's word for it. You'll hear from an eyewitness who was in the alley that night. The only eyewitness in this entire case. You want to guess who's calling that witness to testify today? It's not the government. We are. This eyewitness will tell you that the person he saw in the alleyway was not Alex Callahan. But when the detective interviewed this eyewitness, the detective had already made his mind up. He had decided it was Alex Callahan. During that interview, he, for whatever reason, was carrying a photo of Alex Callahan right in his coat pocket. He pulled out the photo, set it on the table in front of the eyewitness, and asked him, "Is this the person you saw?" When the eyewitness said, "That doesn't look like who I saw," the detective got angry. He snatched his picture back, started pacing the room, swiped a coffee mug off of a table. This is not a detective who was interested in a fair or objective investigation into this murder. This is a detective who decided first and investigated second. Now, when the government didn't get the answers they wanted from the eyewitness, they kept looking. They pulled Alex Callahan's cell phone location data and gave it to their own TBI data analyst. Now, at first, the analyst didn't give them the answers they wanted either. When the detective heard that he once again had not gotten the answers that he wanted, he couldn't handle it this time. This time, he had a talk with the TBI data analyst. After this talk, the analyst all of a sudden was so very certain that Alex Callahan's location aligns precisely with the alley behind the Scala Ristorante, right where Johnny Malone was shot and right where the detective wanted her. So, we checked these records with an independent cell tower expert. Our expert will tell you that the government's expert got it right the first time. Nothing in that cell tower location data places Alex Callahan at the scene of the murder that night. So that's their case. Now, I want to make one thing very clear. As the defense, it is not our responsibility, ever, to call eyewitnesses to testify or to give cell tower evidence. It's because that burden of proof rests squarely upon this table. It is their responsibility to prove that Alex Callahan is guilty of murder. But when the person you've decided is guilty is already in your coat pocket, when you've decided first and investigated second, that is a burden you just can't meet. For that reason, we ask that you find Miss Callahan not guilty. Thank you.
Thank you. Is the prosecution ready to call its first witness?
Yes, Your Honor. The state calls Rory Branigan to the stand.
Okay. And as we discussed, the bailiff will swear all of the witnesses at once if there are no objections.
No objections, Your Honor.
Okay.
No objection, Your Honor.
Thank you.
If all of the witnesses could stand and raise your right hand. solemnly swear or affirm that the testimony that you will give today will be in accordance with the rules of the mock trial?
I do.
Your Honor, before we begin, is this the witness stand you'd like us to use for the duration of the trial?
Yes.
Please state your name for the jury.
Rory Branigan, at your service.
Mr. Branigan, could you tell us a little bit about yourself?
Sure. I'm from Dublin, originally, Ireland.
And when did you move to the U.S.?
Well, my father moved my family to Ironvale County, New Jersey, the Irish New Jersey, as we call it, when I was but a lad. I've been in the States ever since. I got my first major job in Ironvale, and I've felt connected to this country ever since.
What was that first job like?
Well, I had a job working for the Bartola Family Potato Company. The two twins were the founders. From Ironvale, they were. Got me a job when I was younger. It's a shame I had to leave it, though.
Why did you have to leave this job?
Well, believe it or not, I was set up. The twins, they used my goodwill, quite frankly, as a bargaining chip with the devil. The family was alleged of some financial crimes, and I was pinned on it.
What do you do for work now, Mr. Branigan?
Now I work as a bail enforcement and recovery servicier. I enjoy my line of work a good bit, seeing it keeps me on the right side of the people, the government, and the life, if you know what I mean.
Did you know the victim in this case, Mr. Giovanni Malone?
Yes. Giovanni, Johnny Boy Malone. That was what I called him because it was his name. But yes, I knew him very well. The two of us were acquainted. Men of agriculture, we were. 2 peas in a pod. I actually saw him just a couple of weeks before his untimely passing.
What was this last visit with Mr. Malone like?
Well, I was in Bella Vita, it was, for business. I was chasing a debtor across state lines. I was walking through the downtown area of the city, and my eyes passed his face, and I recognized my good friend almost immediately. You know, Malone, he was a real imposing character. I mean, the belly on that man was like the fat cap of a pea. Stubborn as the tutors, he was, but not that day.
What do you mean by not that day?
Something was off. I seen it in his eyes like a famine or a plague. He was disheveled and twitched. Normally, he dressed as sharp as a bishop in the presence of a white-cloaked baby. But on that day, he was no better than a street-dirtied drunkard, you could say.
What did you and Mr. Malone discuss?
Well, we did the song and dance of formalities, but there was only really one woman he talked of.
Objection, Your Honor. Hearsay?
Your Honor, if I may respond. Under hearsay exception 804, subsection A4, declarant unavailable, specifically declarant unavailable due to death, that falls under a hearsay exception as Mr. Malone has passed away and cannot be in court today.
Do you
Your Honor, may I
respond?
respond?
Please do.
Your Honor, I do believe opposing counsel is citing the exception statement made under the belief of impending death. So if I could respond to that.
I'm not, Your
Your
Honor.
As the proponent of this evidence, it is their burden to prove that the declarant, Johnny Malone, did in fact make these statements under belief of impending death. So far, we have nothing that would lay the foundation for this evidence to fall under the exception statement made under belief of impending death, and as such, it is inadmissible hearsay.
Your Honor, if I may, I'm not using the hearsay exception statement under belief of impending death. If I may read from the rule book, under Rule 804A, the definition of unavailability, subsection 4, if the witness is unable to be present or testify at the hearing because of the declarant's death or then existing physical illness or infirmity, they are unavailable.
Right, but under, if I could just follow up with a question, do you satisfy any of the 804B categories?
Yes, we are also doing statement under belief of impending death, excuse me. We believe that Mr. Branigan will go on to testify that Mr. Malone was receiving death threats. Therefore, this witness believed that they were in imminent danger of harm when they were making these statements.
Your Honor, may I respond?
Please do.
Now, Your Honor, you can't unring a bell. The information that we just heard from the witness before I objected was that all Johnny Malone really discussed was a woman named. Presumably, the woman who he was about to name, and before I say this, can I assume that we're outside of the hearing of the jury?
You may.
Presumably, the woman that he was about to name is Alex Callahan. Now, until he gives that information, opposing counsel needs to lay the proper foundation to prove that this falls under the hearsay exception, statement made under belief of impending death. They haven't laid that foundation, and so it cannot come in under that exception.
Your Honor, if I may, Mr. Branigan has just testified that his good friend, Mr. Malone, was disheveled, twitchy, anxious, and that he was talking about Alex Callahan. He will go on to say that Mr. Malone, the victim in this case, gave him a threat on Luxford Financial Stationery.
Your Honor, may I respond?
Briefly.
Your Honor, I saw many students this morning who were twitchy and nervous. That does not necessarily mean that all of them believed in their impending death. As such, we still do not have proper foundation that any of Mr. Malone's statements fall under this hearsay exception.
Your Honor, if I may,
Briefly.
while students may have been anxious and twitchy this morning, none of them, I hope, had received death threats prior to coming to court today.
Yeah, I mean, under B2, the standard is, that the declarant believed his or her death to be imminent, or concerning the cause or circumstances of what the declarant believed to be impending death. I really haven't heard anything that leads me to believe that there was a fear of imminent or impending death, so I'm going to sustain the objection.
Yes, Your Honor. Mr. Branigan, had you heard of the defendant in this case, Miss Alex Callahan, before?
Yes, I had, except I didn't realize it quite at the time. You see, going back to those financial crimes from earlier, the families of Malone and I alike were under some accusations, some suspicions by the government of financial crimes. He worked for the Corsino Family Corn Company. They were doing this big bust on a bunch of Houston-based organizations that were in the agricultural industry. And you see, he was involved in those with me, and past a certain point, I learned of a lady by the name of Penny.
Objection, Your Honor. Improper character evidence.
Do you wish to respond?
I'm not sure what opposing counsel's objecting to specifically.
Your Honor, may I explain?
Yes.
May I assume we're outside the hearing of the jury?
You may.
Your Honor, the testimony that we expect from this witness concerning these financial crimes involves the disappearance of a key witness named Penny Lewis, which ceased these charges from being brought against Mr. Branigan and Mr. Malone. Now, the witness will likely testify to the fact that Alex Callahan was somehow involved with the disappearance of this witness. In this case, they're offering this as propensity evidence to prove that because Alex Callahan acted in accordance with the character trait of being involved with a crime family or some crime in the past, she's more likely to act in accordance with being involved in a crime family or with some sort of crime today.
Your Honor, if I may, we are not using this to go to the character of Miss Alex Callahan, but rather a modus operandi. Mr. Branigan is about to testify that this witness disappeared, and the last person to ever see her was Miss Callahan right after having dinner at La Scala Ristorante, the location of the victim's murder in this case. We are not using it to prove Miss Callahan's character, but again, modus operandi, a method of committing the same crime in the same way.
Your Honor, may I respond?
Briefly.
Now, Your Honor, in this case, if opposing counsel is using this as a modus operandi, it's not really some sort of identity under 404B. Rather, it's offering this evidence to prove that because Alex Callahan was seen with certain people in the parking lot behind La Scala in an earlier situation, she's more likely to have done the same thing in the parking lot behind this restaurant today. As such, it is still improper character evidence and cannot come before this jury.
If you wish to respond, and then I'll rule.
Your Honor, again, we are not using this to go to Miss Callahan's character, but rather for committing the same crime in the same manner, which is extremely relevant to this case.
No, I'm going to sustain this objection as well. This strikes me very much as propensity evidence, given that there really aren't a lot of specific characteristics that would satisfy the modus operandi requirement. So the objection is sustained. Excuse me, you may proceed.
Mr. Branigan, did you and Mr. Malone discuss anything else before you parted ways?
Yes, before I left, he handed me a note he had received recently, and it had some handwriting on it.
Would you recognize that note if I showed it to you today?
I believe I would.
Your Honor, would you like us to ask permission to approach?
You don't need to ask permission to approach the witness.
Yes,
If
Your
you,
Honor.
if you're just approaching to give me a copy of the exhibit, you don't need to ask permission to approach the bench, but if you wish to have a bench conference, please ask permission.
Yes, Your Honor. Let the record reflect I'm showing opposing counsel a copy of what has been marked Exhibit D. Your Honor, would you like a copy?
I would love a copy, thank you.
May I approach?
You may. Thank you.
Mr. Branigan, is this the same note that Mr. Malone gave you?
It's the very same.
Your Honor, at this time, we offer Exhibit D into evidence. Its authenticity has been stipulated.
Any objection?
Yes, Your Honor, I would object to hearsay.
Your Honor, if I may respond, hearsay is an out-of-court statement being used to prove the truth of the matter asserted. In this case, we are not using it to prove the truth of the matter asserted that Mr. Malone really had better make this right or else, but rather for the effect on listener. Mr. Malone believed his life was at risk, which would and was receiving death threats prior to his murder, which shows premeditation. Additionally, this threat was issued on Luxford Financial Stationery, and while that is not a statement, if threats were being issued to the victim on paper from the defendant's company, that's extremely relevant to this case, but not hearsay.
Your Honor, may I respond?
Yes.
I'm going to stick solely to the hearsay objection that I made. Now, the only reason that the government would be offering this note, which says, and Your Honor has a copy,
Of the note, yes, I do.
which says, you better make this right or else, is to prove the truth of the matter asserted, which is that Johnny Malone had better make this right or some sort of consequence would happen. The government's theory in this case is that my client had a motive against Johnny Malone. Certainly this note, which contains the statement, you better make this right or else, is then being offered to prove the truth of the matter asserted, which is that this threat would be carried out if Johnny Malone did not do something.
Your Honor, if I may, we are not, the statement in this would be you better make this right or else, not the fact that this note conveyed a threat, which is what we're using this note for.
Your objection is overruled. I don't think this is being offered for the truth of the matter asserted. You may proceed.
Thank you, Your Honor. May my co-counsel set up a demonstrative for the jury?
Yes, go ahead.
We don't have enough copies, so let's get some people. Could you pass this back? Could you pass this back? Yes. Could you pass this back? Thank you so much. I have a couple more for anyone. Mr. Branigan, could you read this note for the jury?
Yes, it says right up here in handwriting at the top, you better make this right, or else. But when I first received it, what really stuck out to me about it was the paper it's written on.
What was so special about this paper?
Well, it's in this bizarre, fancy business letterhead. You can see right up here at the top, it says Luxford Financial. The paper itself sticks out in other ways. It's a little stocky, high quality, vertically oriented. It's cream white like the froth of an iced Guinness. It's stuck in my memory.
Now, Mr. Branigan, did you meet Mr. Malone again before his passing?
Sadly, no, I didn't. About 2 weeks later, I was approached by apparently authorities, 2 police officers, at my place of residency in Bella Vita, where they informed me of Johnny's unfortunate passing. They took me into an investigation room, and I told them everything I knew. Really, if not for myself, then for my good friend, for Johnny. And I think in the moments since, when I've reflected on my memory of him, I'm reminded of the work of a great Irish author, James Joyce, who writes, "If justice were a drink, it fills a hole in my heart that no liquor will ever seal."
Thank you, Your Honor. No further questions.
Cross-examination, Your Honor?
Go ahead.
May I proceed?
Yes, you may.
Would you like the microphone?
Oh, yes, please. Thank you. Mr. Branigan, you testified on direct examination that you believed the Bartola family was an agricultural organization?
Yes, it was an agricultural organization.
You testified that the Corsino family was also an agricultural organization?
Yes, potatoes and corn they grew, respectively.
And you testified that you had been set up?
Yes, I was.
Before today, you prepared a signed and sworn statement.
That I did.
You were under an oath when you wrote that statement?
I was, yes.
Same oath you're under today?
That is true.
To tell the truth,
Yes.
the whole truth,
Yes.
and nothing but the truth.
Nothing but.
Let the record reflect that I'm approaching the witness with a copy of their affidavit. Now, Mr. Branigan, I want you to read along silently as I read aloud. This is coming from the second paragraph on the first page of your affidavit. I haven't always been such an upstanding citizen in the eyes of the law, though. Back when I was younger, I allegedly, of course, had ties to the Bartola family, a Gulf Coast-based organization. Did I read that part of the paragraph correctly?
Yes, that's exactly what it says.
You then say the Bartola family has some loose ties to, allegedly, of course, Tennessee criminal organizations. I read that part correctly?
Yes, that's also true.
You then say, I gave that life up a long time ago. Read that correctly?
Yes, that is all correct.
All right, now I want to talk about how you knew Johnny Malone. Back in 2014, you two were actually arrested together.
Objection, Your Honor. This is more prejudicial than probative. An arrest is not a conviction, and I believe it would unfairly prejudice the jury against Mr. Branigan.
Your Honor, may I respond?
You may.
Now, Your Honor, for this evidence to come in under Rule 403, it has to pass a balancing test. The danger of unfair prejudice, the probative value must not be substantially outweighed by the danger of unfair prejudice. Now, in this case, the probative value is going to go straight to this witness's credibility. Further testimony will confirm that this witness was arrested for charges of money laundering, something fraudulent. This goes directly to the witness's character for truthfulness or untruthfulness, and as such, his credibility, which needs to reach the jury.
Your Honor, if I may, there is a specific exception for conviction for a crime of dishonesty, but to be clear, Mr. Branigan was only arrested and he was released, the charges were dropped. So providing this evidence to the jury would unfairly prejudice them against him when he did not commit this crime.
Your Honor, may I respond?
You may.
Now, Your Honor, I am not citing Rule 608 or 609, which talks specifically about acts or crimes of dishonesty, as that relates to Rule 404, which is character evidence. In this case, I'm specifically addressing the 403 objection, which says that the danger of unfair prejudice substantially outweighs the probative value. The probative value goes straight to the witness's credibility and is not substantially outweighed by any sort of danger of unfair prejudice.
Do you have a response?
Your Honor, an arrest, again, is not a conviction. And telling this jury that Mr. Branigan was arrested for a crime that he was eventually acquitted for may cause them to believe that he did in fact commit that crime when he didn't, and bias them against him when he did not commit this crime. He just testified that he did not commit this crime. And it doesn't make any of the facts of consequence in this case more or less likely.
I'm going to overrule your objection. I think this is being offered for a permissible purpose, and I don't think it's more prejudicial than probative. So you may proceed with your witness.
Back in 2014, you and Mr. Malone were arrested together.
Yes, we were set up alike, it is true.
For money laundering.
Yes, for money laundering on parts of the company.
Money laundering is when you make money illegally, and then you make it look as if it came from a legal source.
That's about what they said. I'm a farmer, I don't know much about money laundering.
Fraud.
Fraud.
And let's be honest, Mr. Branigan, you did it.
Sorry, could you repeat that one real quick?
You did it?
I did the money laundering?
Yes.
I was set up. I was a potato farmer for about a decade of my life when I was younger.
According to you, Mr. Branigan, you and Mr. Malone were only mostly innocent?
Only mostly innocent on the basis that we had been involved with companies that had alleged ties to criminal organizations. Something which I, by the way, was not entirely aware of until this trial had actually taken place.
All right, now let's talk about this note that Mr. Malone found on his car. This note,
Yes, that one.
it says, "You better make this right or else."
Yes, that's what it says.
And now, Mr. Branigan, you cannot tell us what this is referring to.
Not exactly. I'd assume it pertains to something regarding Callahan, but yes.
You can't tell us what "or else" means.
Not necessarily. It has some kind of form of, I'd say, finality to it with the underlines and the exclamation points, but yes.
Can't tell us what it means?
Not quite.
And you can't tell us who wrote this note.
No, I cannot. All he was talking about was Alex Callahan and the build-up to giving me this note.
Now, according to you, Johnny Malone handed you this note so you could see it.
Yes.
Then, according to you, Johnny Malone ran away.
Yes, he left in a bit of a hurry. He was acting strange.
And so you took this note and you put it in your pocket,
I did, for safekeeping.
then you forgot about it.
It slipped my mind for a couple of weeks while I was chasing down this debtor, but yes, I kept it with me the entire time.
And it only resurfaced from your safekeeping after Mr. Malone had died.
Yes, when the authorities came to me and brought me into the investigation room, they told me to refresh my memory on anything that might be helpful, which is when I remembered the note and brought it in.
And now I want to talk more about why you knew Mr. Malone. Now, you were involved in the Bartola crime family,
The Bartola Potato Farming Company, yes.
and Mr. Malone was involved in the Corsino crime family.
I'm not sure why you're saying crime family, but yes, Corn Company.
And Mr. Branigan, would you agree with me that we read from your statement that the Corsino and Bartola crime families had alleged ties to Tennessee criminal organizations?
If they were crime families, why would they need ties to other criminal organizations?
Would you agree
to
that we
act
read that
closely?
from your statement, Mr. Branigan?
Say again?
Would you agree that we read that from your signed and sworn statement?
Yes, allegedly, it says.
And you can tell this jury that never in your time in the Bartola crime family did you ever meet Alex Callahan.
I did not. I was not aware of the existence of Callahan until that trial had happened.
You can tell us that you never heard Alex Callahan's name.
No, not until the disappearance.
The first time that you heard Alex Callahan's name was when Johnny Malone told you about her on November 3rd.
No.
That's incorrect?
Yes, that is incorrect. The first time I ever heard Callahan's name was at the trial. I heard it from a number of people around. It was the talk after the disappearance.
So it's your testimony here today that you heard Alex Callahan's name in the midst of a trial?
Yes. From Malone was one of the people who told me, but yes.
You still have your statement on the
I do.
witness stand? All right. Signed and sworn, right?
Yes.
Same oath you're under today, right?
Very true.
And you can tell this jury that nowhere in the statement where you agreed to tell the whole truth do you say that the first time you heard Alex Callahan's name was in any sort of trial.
Could you please point out a section that specifically opposes what I've said?
Mr. Branigan, I can't point out a section because it's not in there. Is that true?
Well, no, not necessarily. I heard about it from the trial, but the talking surrounding it, it was a major scandal in the Houston-based area, especially in the Iron Vale community. I knew the twins, I knew multiple higher-ups at both companies. I was very well acquainted with the agricultural industry up to this point. There were a number of people that reminded me of the name Alex Callahan, and then the disappearance happened, and it all fell apart.
Mr. Branigan, I'm going to give you 7 seconds to find in your affidavit where you mention that you heard Alex Callahan's name during a trial. Not in there, is it?
You've only given me 7 seconds.
Thank you, Mr. Branigan. No further questions.
Any redirect?
Briefly,
Would you like the microphone for your redirect?
It's okay.
Mr. Branigan, to be clear, are the Corsino and Bartola families crime organizations?
No, they are not.
Why did you end up severing your ties with those two families?
Okay, so after about a decade or so of working for them, I'd say, I was pinned by the very same twins that ended up hiring me into the job, the twins that I grew up with, the twins that I knew as children. After my pinning, I left the family, which is the only reasonable thing for me to do, and as opposed to going back into an agricultural job, I ended up pivoting to bail enforcement because my bad experience with the law had really put my life in a certain direction.
What would anyone talking about criminal ties in these families be referring to?
Most likely whatever went on among the higher-ups. If the corporate's ladder was a physical ladder, well, I was only maybe the second or third rung, a more basic, maybe somewhat advanced farmer. The twins themselves were the founders. We're talking 7th, 8th rung. Maybe up on the highest levels, there was some criminal involvement, which is why I wrote allegedly in my witness statement that there were criminal ties. But I was not aware of them until I was one of the people pinned.
Thank you, Your Honor. No further questions.
Thank you. Any recross?
Nothing further from this witness, Your Honor.
Okay. The witness may step down. Thank you for your testimony. Oh, you can take it back.
Thank you very much.
Okay, is the prosecution ready to call its next witness?
Yes, Your Honor. The state calls Mr. Sky Gonzalez.
The witness has already been sworn. You may proceed.
Good evening.
Good evening.
Could you state your name for the court?
My name is Sky Gonzalez.
What do you do for work?
I'm a culinary artist at La Scala downtown.
A culinary artist. Are you a chef?
No. Those unaffiliated with Le Travail Culinaire, that's French for the culinary work, would call someone like me a waiter. Most people, they think that it's the chef or the owner or even the valet who's in charge of making sure people get good food and have a good time. Those people would be wrong.
So what exactly does your job at La Scala consist of?
The usual stuff. It's my job to make sure everyone's having a good time. I bus tables, I take orders, I make sure nothing bad's going on, make sure everyone's happy. Unless there's truly a tragic moment, and then I take some time to grieve with the customers.
Has the defendant, Alex Callahan, ever visited your restaurant?
Yes. Miss Callahan, she comes by all the time. She's always bringing one of those fancy business guests with her. Good tipper, too.
When was the last time the defendant was at the restaurant?
The last time she ate there had to have been October 25th. It was a real weird time.
What was unusual about this particular visit?
Well, if you're going to get me started on that, first I have to talk about who she was eating with, Mr. Malone. Now, as many customers do, he ordered our clam linguine. It's one of our more popular dishes. But then he ordered apple juice. It was a horrifying combination. I almost didn't bring it to him.
Besides the food, did anything interesting happen during their meeting?
Yes. The conversation seemed normal at first, but it was tense. It was like watching a teetering stack of plates. I tried to stay close to the table to catch some of the conversation.
Did you hear the defendant say anything in particular?
Yes, I heard the defendant say, "You've put us in a precarious position." And she stood up and she scribbled a note on a napkin right after that. And then she threw the napkin at Mr. Malone. After that, she was off in a huff, faster than I've seen anyone leave the restaurant. She even left her iconic orange scarf behind.
Objection, Your Honor, improper character evidence may be heard outside the presence of the jury.
You may.
Now, Your Honor, this witness has just testified to the fact that Ms. Callahan was seen wearing an orange scarf the night of October 25th. Now, I expect further questioning from this witness to show and prove that someone was seen wearing an orange scarf the night of the murder. Now, what opposing counsel is going to attempt to link is Ms. Callahan wearing an orange scarf on October 23rd to the person wearing the orange scarf the night of the murder. The problem is this witness is not going to be able to identify this person, nor is this witness going to be able to identify anything about the person that identified the person in the orange scarf. They're trying to offer this to show that because Ms. Callahan was wearing an orange scarf on October 25th, she's more likely to be the person wearing the orange scarf on November 17th.
Your Honor, may I respond?
You may.
If I may proffer, we are not going to ask this witness to connect this orange scarf specifically to Ms. Callahan at the scene of the crime. And additionally, this evidence goes to weight and not admissibility. This is up for the jury to decide if the fact is relevant to the case. It's up to the jury to decide if it relates to Alex Callahan. We will not be asking this witness to make that connection. That is the jury's responsibility.
May I respond, Your Honor?
You may.
We agree this could be offered for weight rather than admissibility, and if I may quote the rule, upon request, an out-of-court jury hearing must be held in order to resolve the matter at hand. In order to find, in order to find action conforming with the character trait, there must, upon request, be an out-of-court jury hearing under 404B subsection A. And I ask that we hold that hearing now.
Do you wish to respond?
Your Honor, all I wish to say is that this evidence is to be determined by the jury. We are not asking Mr. Gonzalez to connect this scarf to Ms. Callahan. This is a fact that it's up to the jury to decide how relevant it is and if it connects the defendant at all.
Yeah, I'm going to deny your request for a 404 hearing. I'm also going to overrule the objection. I think the witness is just being asked to testify about what he observed on that evening. This is not character evidence.
Yes, Your Honor.
Thank you.
Thank you, Your Honor. I'll ask again, could you tell us a little bit more about that meeting with the defendant and Mr. Malone at the end?
Yeah, it was tense. It was uncomfortable to watch. Whenever I got closer, I heard what Ms. Callahan said. She said that Mr. Malone had put her in a precarious position, and she threw the note and left her orange scarf behind.
Did you see the defendant ever again at the restaurant after that?
Yes, a couple of days later, she went and picked up her orange scarf. I can't blame her. It was the most classy garment of clothing I've ever seen. The autumnal colors on it were truly amazing. It helped me get through some of my tougher days, especially after my divorce, seeing it on the coat rack there.
Did you see Mr. Malone at all after this meeting?
Yes, he came in later on the night of the murder.
Did Mr. Malone do anything?
Yeah, he just sat in a booth and then checked his phone a couple of times.
Did he do anything else?
No, he just checked his phone one last time and then got up and exited out the back alley.
What happened next?
There were two loud bangs and he was shot. At first, everything in the restaurant was quiet. It was like it had been paused in there or something. But then everyone started to panic. People were flipping over tables. They were screaming. I didn't know what to do at first.
What did you end up doing?
I called 911 eventually. But when I was on the call, one of the busboys that would run into the alley, as brave as he was, he said, someone's been shot. Someone in an orange scarf just ran down the alley.
Are you sure they said someone in an orange scarf?
Yes, they said that someone in an orange scarf had run down the alley.
Thank you, Mr. Gonzalez. No further questions at this time, Your Honor.
Okay, thank you.
Cross, Your Honor.
Go ahead.
Thank you. May I proceed, Your Honor?
You may.
Good afternoon, Mr. Gonzalez.
Good afternoon.
Mr. Gonzalez, let's talk about this case as a whole for a second. If it were up to you to decide whether my client, Alex Callahan, got convicted of murder today, you wouldn't have to think too hard about it, would you?
Well, based on what I've seen, I do think that she did it.
The fact is, you're certain it was Alex Callahan who killed Johnny Malone.
Yes, based on what I've seen, that makes sense.
As soon as the shooting took place, you made up your mind who did it.
Yeah, I mean, based on what I'd seen, it did make sense.
You told all your friends about it. You told them that shooting behind my restaurant at La Scala, certainly was Alex Callahan who did it.
Yeah, I wanted them to be safe. I didn't want them to be in any danger.
Now, Ms. Callahan came to the restaurant on October 2025, or it was October 25th, 2025, right?
Yes, that's correct.
That night, she was with Johnny Malone.
Yes.
Let's talk about that night. You actually waited on them that night, didn't you?
Yes, I did.
You took their orders,
Yes,
brought it back to the kitchen,
I did.
and then you started eavesdropping on them.
I don't know if eavesdropping is the right word. I was doing my job, trying to make sure they were having a good time. Maybe there wasn't any problem with their food.
Let's be clear, eavesdropping is the right word because you were intentionally hovering around their table specifically in order to hear what they were talking about, right?
Yeah, I was trying to make sure they had a good time at the restaurant.
Let's be clear, the only thing you heard was one statement from Miss Callahan.
Yes, I heard her say you put us in a precarious position.
If I were to ask you to tell this jury what Miss Callahan meant by "you've put us in a precarious position," you couldn't tell them, could you?
I could not.
You couldn't tell this jury what Miss Callahan said before this.
No, I don't know if she said anything before that or not.
You don't know whether she said anything after this.
Well, after that, she wrote the note and then threw it at Mr. Malone and left.
But you have no idea whether she said anything before or after.
Well, she left after that.
You have no idea. You were not listening and you could not hear anything else. Is that a yes to my question?
That was the last statement I heard before she left. I don't know if she was talking to herself after that, but
You did not hear anything else.
I did not.
Thank you, Mr. Gonzalez. Now, let's talk about the next time Mr. Malone came to the restaurant. That was November 17th, 2025.
Yes,
He came into the restaurant.
he did.
He sat down at a table.
Yeah.
But that night, you didn't actually wait on him.
No, he wasn't in my section.
It was an unusually busy night, especially for a Monday, right?
Yeah,
You couldn't tell whether anyone was sitting with him that night, could you?
I could not.
You couldn't tell at any point during the night whether anyone came to the restaurant and spent any amount of time with Mr. Malone.
I didn't see anyone do that.
That was the night Mr. Malone was murdered, right?
It was.
That was the night he died.
Yeah.
Now, you can admit to this jury that when you first heard the sound of the gunshots, you thought it was a bird.
Very briefly, but I quickly realized that was wrong.
But everything got cleared up when a busboy came into the restaurant yelling.
Well, he ran into the alley and shouted what he saw.
You heard this busboy yell, "Someone just got shot by someone in an orange scarf."
Well, he said someone just got shot, yeah, and that someone in an orange scarf was there.
What was the name of the busboy that yelled that?
I don't know the name of all our staff. We have a lot. It's a big restaurant.
Mr. Gonzalez, you've been working at the restaurant for a good bit of time, right?
Yeah.
You work there a lot of days out of the week.
Yes, I do. It's my job.
But you can't tell us the name of the busboy that screamed at the top of his lungs, which you heard above everything else. You can't tell us his name.
No, I don't know the name of all our staff. It's a changing staff. We don't just keep the same staff always. Sometimes people quit. I don't know all their names.
You said he was in the alley. Did you actually see this busboy?
Yeah, I saw him run into the alley.
Okay, but you were inside the restaurant.
I was. That's correct.
Okay. Mr. Gonzalez, let's talk about something different. The fact is, you're actually glad to be here testifying today, aren't you?
I am, yes.
You're glad to be telling this jury that Alex Callahan is the person responsible.
Yes, I'm glad to try to bring justice and do what's right for the city.
It's not just the fact that you're trying to bring justice. You actually plan to sell this story you just told us, right?
I got a couple of calls. I think that's what you're referring to.
I am referring to the calls. It was the calls about selling this story.
Yes, but it's nothing concrete, just a couple of calls.
Just a couple of calls, but if you were to sell this story, you would make money off this story, right?
I don't know for sure, presumably. I don't know exactly how all that works.
You've actually had multiple calls with multiple producers already about selling this story.
Yeah, a couple of calls.
No further questions.
Any redirect?
No redirect, Your Honor.
Okay. The witness is excused. And are we ready for our final prosecution witness?
Yes, Your Honor. The state calls Dr. Lee Waldo. Before I begin, may my co-counsel and I set up 2 demonstratives in the well, not facing the jury, to be flipped later.
Sure. Go ahead.
May I proceed?
Go ahead.
Good evening.
Good evening.
Could you please introduce yourself to the members of the jury?
Absolutely. My name is Lee Waldo.
Dr. Waldo, what do you do for work?
I'm a digital forensic specialist currently in TBI,
And how long have you been a digital forensic specialist?
going on 14 years, but I've been in the field for almost 25.
So then, how exactly are you involved in this case?
I was asked by the state's investigator to use Alex Callahan's cell phone activity to determine where she was the night Mr. Malone was murdered.
Before we get more into your work on this case, I'd like to take a step back and talk about your background. Where did you go to school?
I got my bachelor's in physics from UT Knoxville. After that, I got my master's in telecommunications engineering from Vanderbilt. That was followed by a PhD in computer and electrical engineering from Georgia Tech, where my PhD dissertation was actually in cellular triangulation in dense urban areas, which is the exact same environment I analyzed in today's trial.
Your Honor, at this time, the state moves Dr. Waldo to be entered as an expert in cellular triangulation and telecommunications engineering.
Is there any objection?
No objection, Your Honor.
Okay, admitted. Thank you.
Dr. Waldo, how did you start your investigation for this case?
Well, I started by looking at Alex Callahan's call detail record and a map full of corresponding cell phone towers.
Would you recognize a copy of the call detail record and the cell phone towers if I brought them before you?
Yes, sir.
Your Honor, may I approach the witness with exhibits F
You may.
and G? Thank you.
Your Honor, may I see?
Yes, showing opposing counsel. Would Your Honor like copies?
I would. Thank you. Thank you.
Dr. Waldo, what are these documents?
Exhibit G is Alex Callahan's cell phone activity, and Exhibit F is a map, all the cell towers that her phone connected to the night of the murder.
Are these fair and accurate copies of those documents?
Yes, they are.
Your Honor, at this time, the state offers exhibits F and G into evidence. Their authenticity has been stipulated.
Any objection?
Yes, Your Honor, I have an objection to Exhibit G, hearsay.
Your Honor, if I may respond.
Please
Pursuant
do.
to Rule 703, subsection A, experts are allowed to use hearsay in order to explain to the jury how they came to their conclusions under the circumstance that the probative value of the evidence substantially outweighs its prejudicial value. In this case, the probative value is defined as the probative value in the jury's understanding. This witness is about to testify to complicated terms like azimuth and timing advance and how you can use them in accordance with the cell tower map in order to determine someone's location through cellular triangulation. These are complicated topics that the jury would need to see this evidence to understand. Thus, it is permissible to show this to the jury through 703 subsection A.
Your Honor, may I respond?
You may.
Under Rule 703, in order for this to be admissible, the prejudicial effect or the probative value has to be substantially outweighed by the prejudicial effect has to be substantially outweighed by the probative value. In other words, it's a reverse 403. In this case, they are not calling the person who created this record, so the prejudicial effect substantially outweighs the probative value.
Can you be more specific about what the prejudicial effect is here?
Yes, Your Honor. This report or this record was not created by Dr. Waldo. It was the call detail was created by someone in the cell tower business that ran the signals of downtown Bellevue. So they are not calling this witness, and this witness cannot be crossed. So the prejudicial effect is outweighs the probative value.
But you're not making a confrontation clause argument.
No, ma'am.
Okay, I'm going to overrule that objection and admit the exhibit.
Thank you, Your Honor. May I flip around these two demonstratives?
You may.
Dr. Waldo, what exactly do these documents tell us?
Well, Exhibit G is all the raw data that I gathered for Alex Callahan's cell phone activity with my notes in the last column, and Exhibit F is a map of all the cell towers.
Your Honor, may Dr. Waldo step down to annotate these demonstratives?
Is there any objection?
No objection, Your Honor, only that I move to see it as well.
Of course, go ahead.
Dr. Waldo, I'd like to talk about these documents, starting with Exhibit G. Could you define azimuth for the jury?
Absolutely. Azimuth is the angle at which a signal is sent from the cell tower to a phone.
What about timing advance?
Timing advance is the number of times the phone pings the tower in a microsecond. Essentially, the higher the number, the closer the device is to the tower.
Moving on to Exhibit F. What was the first tower the defendant's phone connected to on November 17th?
Well, the first connection was to tower 1109, right here. That timing advance, the azimuth, places it amongst this device amongst her financial. Alice Callahan's place of work.
What about the next connection at 927?
Well, at 927, the device pinged the exact same tower. This time was at a higher timing advance. This means the device would have been closer to the tower. So, as the device moved east, it had to go north towards the tower, and then west towards Whitlock Street.
I noticed that there are two pings at 955. Could you walk the jury through the first one?
Absolutely. There are two pings at 955. The first one is the stronger and more accurate ping. That was to the tower 1213. And with that had an azimuth 9, meaning it was extremely close to the tower. Furthermore, the azimuth places the device in this center, anywhere in this center, right here, containing the skull.
What about the other connection at 955?
Then the signal handed off to tower 1222. This tower right here, at a much, much lower timing advance of 3, which means that it could have been anywhere in this given radius here. The azimuth, furthermore, centers the sector in this signal. Here, placing the device anywhere in this quadrant.
And what do these two connections tell us about the defendant's phone location at the time of the murder?
In 955, which is the time of the murder, there were two connections. They have the one abundance. It was this tiny sector right here. And at that point, right here is the skull. Two sectors that intersect are the skull and restaurant at the time of the murder.
Thank you, Dr. Waldo. You can take your seat. Dr. Waldo, based on all of the data presented today, what is your conclusion?
I can say with professional certainty that Alice Callahan's device was located within walking distance of the skull at the crime scene in 955, the time of the murder.
Finally, Dr. Waldo, if the defendant's phone was connected to Wi-Fi during this time period, would any of these cell call detail records exist?
Absolutely not. You see, when a device is connected to Wi-Fi, it completely bypasses cell towers, goes through a wireless router. This means the defendant's phone had to have been connected to a cell tower, not Wi-Fi, during this time.
Thank you, Dr. Waldo. Thank you, Your Honor. Nothing further at this time.
Thank you.
Cross-examination.
Go ahead.
Counsel, would you like me to take down these markers?
That's all right. Before I begin, may I have set up in my place?
I'm sorry, I couldn't hear.
Oh,
Oh, yes.
Now, Dr. Waldo, you'd agree that cell tower location data is not exact.
Not always, no.
It's not like GPS technology, which shows the device's precise location within a few feet,
That's correct.
which also updates constantly in real time.
Yes.
Cell tower data is not updated in real time.
No, it's whenever there's a system ping.
You only get usable information anytime a phone sends or receives data.
Absolutely.
And you're limited only to cell tower coverage areas.
Of course.
Not only that, but several factors can make cell tower data even less reliable,
Yes, absolutely.
including building materials,
Yes.
topography,
Yes.
weather conditions.
Absolutely.
And if there are a high concentration of users in a small area at one time, certain devices are going to get handed off to other towers.
No,
That's not correct?
that's not correct. See, when a lot of people go to turn on their phones, let's just say they have to send a text, they connect to any tower that has open availability.
Right, so if there are high concentrations of users in a small area and the nearest tower is full, they're going to jump to the tower with the closest signal.
Yes, the ones who join the connection, join the network.
Right. Now, in other words, if I make a call right now when it's not busy, my phone will likely connect to a nearby tower.
Absolutely.
But if there's a game getting out of the stadium just over the Cumberland and thousands of people are on their phone all at once, my call might get bumped to a tower further away.
Not if you were previously connected to the close tower.
But if that tower is filled up with the fans from the game, my phone will move to the tower with the strongest signal, as you explained earlier.
Not necessarily. See, when a ton of people join a network at one time, their phones and their devices will connect to a tower with space and no limited availability. Your phone will stay connected to the tower that it was previously connected to, unless there's actual movement of the device.
Dr. Waldo, I want to talk about these issues in context with this case. I'm going to show you an enlargement of Exhibit F. Do you have that up there with you?
Yes, ma'am.
Now, this is a map of the downtown area.
Yes.
You'd agree that the downtown area has large concrete and metal buildings.
Absolutely.
Exactly the kinds of materials that can interfere with cell signals.
Yes, but this was a completely clean data set. There was no interference at all.
Next, we can see that there are 3 towers that cover the downtown area.
Yes.
They're all within a few blocks of each other.
Yes, ma'am.
You'd agree there is overlap in the coverage area of these 3 towers.
Absolutely.
Now, you're also aware that the soccer game that let out right before the shooting was here at this stadium.
Yes.
Now, Dr. Waldo, you were never provided any records showing how much overall usage each of the towers was experiencing at the time of the shooting.
Absolutely, because as I said, it would not matter for Alex Callahan's device, which was previously connected to a tower.
You were never provided any of these records?
No, of course not.
Nor did you ask to be provided these records?
Because as I said, it wouldn't change anything.
I'm now showing you an enlargement of Exhibit G. You had this one as well?
Yes, ma'am.
This is an excerpt of call data from Alex Callahan's phone.
Yes.
And these are your notes in the right-hand column.
Yes, ma'am.
According to you, this data set was clean with no anomalies, as you said earlier.
Absolutely.
We can see the system ping at 9:55 p.m.
Yes, the 2 of them.
It was at tower 1213.
Yes.
Then, just seconds later, still at 9:55, there's another ping at tower 1222.
Yes, which
No.
indicates movement because of the signal handoff.
Dr. Waldo, you'd agree with me, though, that if this device was moving toward Luxford Financial at 9:55, it would be moving away from tower 1222.
Oh, absolutely. But it wasn't moving towards Luxford. Would you like me to get down so I can demonstrate?
No, that's all right. I think you've answered my question. Now, this device was moving toward Luxford Financial?
No, it was not. See, at 9:55, it connected to tower 1222.
Right.
Then at 10:02, it was still connected to tower 1222, moving closer towards that tower. It was moving north on Whitlock Street, closer to the tower.
Dr. Waldo, tower 1222 is in the opposite direction of tower 1109, which is next to Luxford Financial, the defendant's employer.
Yes, I never said that. The defendant's phone made its way back towards Luxford Financial at the end of the night. It moved its way north.
Well, I want to talk about how a digital forensics expert like yourself is supposed to reach a conclusion.
Absolutely.
You'd agree you investigate the facts before reaching conclusions.
Absolutely.
You should never decide first and investigate second.
No.
Dr. Waldo, you'd agree that you'd admit to this jury that after you first read the data, you concluded something different than what you're telling the jury now?
No, absolutely not.
Is it your sworn testimony today that you did not conclude something different?
No, I've always stated that Alex Callahan's device was located within walking distance of the skull.
Now, before this trial, you prepared an affidavit.
Yes,
In the affidavit, you swore to tell the truth, the whole truth, and nothing but the truth.
absolutely.
I want you to read along silently as I read aloud. It's page 2.
Absolutely.
You said, "It's true that I initially wrote a draft preliminary report that concluded that there was only a decent probability and likelihood that Alex Callahan's phone was in the area of the restaurant at the time of the murder." I read that correctly?
Absolutely. My
All right.
conclusion never changed. It's only my level of certainty.
Dr. Waldo, did I read that correctly?
Yes, absolutely.
Objection,
Thank
Your
you.
Honor. The witness is allowed to explain her answers on cross-examination.
Are you finished with that line of questioning?
With the impeachment, yes, Your Honor.
Okay, you can proceed.
Now, this second conclusion, you only arrived at this second conclusion after you talked with Detective Paris.
Yes, to go over the timeline.
And your conclusion went from decent probability and likelihood to professional certainty.
Yes. You see, I had all these data sets, all these numbers, and I had a general idea of what it meant. But I didn't know if it was actually possible for someone to get from Luxor Financial to get to La Scala in a given time. After talking with Detective Paris, I realized it was more than possible that Alex Callahan would have gone from Luxor Financial to La Scala in a given time.
You'd agree that your opinion went from decent probability and likelihood to professional certainty?
Oh,
Is that a yes?
absolutely.
Thank you.
Yes.
Now, you'd also agree that your conclusion went from Alex Callahan's phone was in the general area of the restaurant to the alleyway behind the restaurant.
No, it was always in the area of the restaurant, absolutely.
Well, you told your conclusion to Detective Paris that it was in the alleyway behind the restaurant, and you've testified to that today.
Yes, absolutely, within walking distance.
Right now, Dr. Waldo, after you helped Detective Paris with this case, Detective Paris helped you with your career.
And what are you referring to?
Detective Paris put you in touch with law enforcement agencies across the state for you to provide private training.
Yes, that's my job. I'm the lead instructor of the TBI Cellular Evidence Reconstruction Training Course.
So far, you've been privately retained to give more than 20 weekend training sessions this year alone.
Yes, ma'am.
And you actually want this to become your full-time job in the next few years.
Absolutely.
So, in other words, after you helped Detective Paris with this case, Detective Paris helped you with your career.
Not necessarily.
Objection, Your Honor. They're past time.
Were they past time?
Yeah.
Okay,
I
please.
think I've made my point.
All right, please wrap up.
Different.
Thank you.
Would you like to proceed?
Yes, please.
Got it. Okay.
Redirect, Your Honor.
Go ahead.
Dr. Waldo, did your conclusion change at all after your discussion with Detective Paris?
Absolutely not. The evidence has always shown that Alex Callahan's phone is located in walking distance of La Scala at the time of the murder.
Then what changed?
It was ultimately my certainty. See, I already decided that it was very likely, it was probable, but I didn't understand if it was even possible for someone to get from Luxor Financial to La Scala. After reviewing the timeline, I realized it was possible, and I changed it to professional certainty.
Thank you, Dr. Waldo. Thank you, Your Honor. Nothing further.
Thank you. You may step down. Okay. Is the defense ready to proceed with its witnesses?
Yes, Your Honor. The defense calls Dr. Joe Santiago to the stand.
Okay, Dr. Santiago, you may approach the witness stand.
Before I begin, Your Honor, may I set up an enlargement of Exhibit F?
You may.
Please tell us your name.
My name is Dr. Joanne Santiago.
What do you do for a living?
I'm a professor. I teach telecommunications engineering at Vanderbilt University.
What is telecommunications engineering?
We design and study the wireless transmissions through which calls and data travel from one device to another. I like to teach my students that we're like engineers who design highways, only our highways are invisible, and they carry millions of data signals per second, all moving at light speed.
How long have you worked in telecommunications?
Almost 20 years. I spent 10 years in the field working as lead engineer for one of the largest telecom companies in the world, and the rest in academia.
What degrees do you have?
I have a bachelor's, master's, and PhD, all in computer science with a focus on telecommunications.
Your Honor, we tender Dr. Santiago as an expert in telecommunications engineering.
Any objection?
No objections, Your Honor. I'd just simply like to clarify now that cellular triangulation is not a subset of telecommunications engineering and is its own specific field that this witness must lay further foundation for and be tendered specifically as an expert in before she can testify to the field.
Your Honor, may I respond?
You may.
Telecommunications is absolutely the broad category for cell tower triangulation and cell tower data. We've already laid plenty of foundation that this expert has gone through education, she has skill, expertise in this field, and she would absolutely have knowledge of how a cell tower works, radio waves, anything under that subcategory.
Any response?
Yes, Your Honor. Opposing counsel is precisely correct. Cellular triangulation is, in fact, a subset of telecommunications. However, it is an extremely precise and specific subset of telecommunications that involves law enforcement usage of cellular signals in order to determine someone's location. Trying to enter an expert in broadly telecommunications as an expert in cellular triangulation would be akin to trying to enter a common doctor as a neurosurgeon. It's simply too precise and too complicated a field to be able to testify to as an expert in telecommunications engineering.
Can you lay a foundation for cellular triangulation?
Your Honor, if you would like, I can say that this expert is not an expert in cell tower triangulation, but rather cell tower location data, which covers the broad area, but she will extrapolate further later on.
Okay, I'm going to admit the witness with that in that category of expertise.
Yes,
Thank you.
Thank you.
Now, Dr. Santiago, Dr. Santiago, what were you asked to do in this case?
I was asked to review the conclusions provided by the TBI digital forensic investigator regarding the location of Alex Callahan's mobile device on November 17, 2025, and determine whether those conclusions were supported by the data.
Are you being paid for your time?
I am.
And just for upfront with the jury, did you know Alex Callahan before this case?
I knew Ms. Callahan somewhat. In my early 20s, I was a part of a professional networking group. Me and Mrs. Callahan were a part of this group together, and we've been in touch here and there since then.
Now, what data did you review in reaching your conclusions?
I reviewed all of the same materials as the TBI digital forensics investigator, as well as the TBI's report. I also reviewed some materials that TBI did not review, which were carrier coverage data of the Metro Bella Vita area, a zoning and topographic map of the area, and National Weather Service data for November 17, 2025.
From your review of that data, did you reach an independent conclusion as to whether the TBI digital forensic investigator got it right?
I did.
Objection, Your Honor. This calls for this witness to make a conclusion in the field of cellular triangulation. Dr. Waldo, with the TBI's conclusion, was founded on the field of cellular triangulation, a field in which this witness has not been entered as an expert.
Do you have a response?
Your Honor, this expert can give her opinion on whether the TBI digital forensic investigator got it right because she is an expert in cell tower data location, as I said before, rather than cell tower triangulation. I don't believe that, that's my response.
May I respond?
Briefly.
Cell tower data location is a field that specifically defines the analysis of these signals. Dr. Waldo's expertise extends to using these signals to determine someone's location. I'm fine with this witness testifying to these signals and their quality and what those signals themselves. However, once this witness's testimony strays into a field of using those signals to determine someone's location, For example, asking her to talk about the quality of Dr. Waldo using those signals to determine someone's location, it strays outside of her field of expertise.
Your Honor, may I respond?
You may.
What we're doing with this expert is exactly what he's saying that we're doing. We are saying that she will not be able to determine the pinpoint of the defendant's phone. So she is not using this evidence for cell tower triangulation, but rather a lack of cell tower triangulation data that can be determined from the facts.
I'm going to allow the witness to testify. I think we're getting a bit too granular with the categories of expertise, so you can proceed with your witness.
Yes, Your Honor.
Thank you.
Thank you.
Now, excuse me. I'm going to ask that question again. From your review of that data, did you reach an independent conclusion as to whether the TBI digital forensic investigator got it right?
I did.
Now, before you tell us your conclusion, can you explain how cell phone data location works?
Sure. Most people think that phones just talk to other phones. Well, they don't. All phone calls across all cellular networks are routed through cell towers. Whenever a call is placed from a phone, the phone will connect to a tower somewhere in the area, and a record is created showing which tower was used. Although many towers have overlapping areas, and many areas of the country will get little to no coverage at all.
And how accurate is cell tower data in determining a person's precise location?
It really depends. It's definitely not like GPS satellite technology, which will tell you a device's location within a few meters. With students, I teach them that cell towers tell you a device's location more reliably at where it is not, rather than where it is.
What do you mean by that?
If I were to call you on my phone now, it may register at a tower in this sector of downtown. It may hit the tower several blocks away, or it may hit the tower off Riley Parkway several miles away. But my phone will definitely not register at a tower in, say, Knoxville or Chattanooga.
Now, you said the accuracy of cell tower location data depends. Depends on what?
It depends on many things. First, it depends on the number of towers in the area. In rural areas, you may have one tower for every 10 to 20 square miles. In urban areas, you may have 10 to 20 towers for every 1 square mile. The more towers nearby, the more overlapping coverage you'll have among those towers, meaning the less likely the tower data can tell you really anything about location. And then it's even worse in urban areas with large and metal buildings close together. That can greatly interfere with signal transmission. On top of that, anytime you have a large concentration of people in one small area, all of their devices are going to be competing for the same tower coverage, meaning many of their devices are going to be handed off to towers that are further and further out.
Dr. Santiago, when a device is used, does it always go through the closest tower?
That's a common misconception. It's not the proximity of the tower that matters, it's the connectivity. You see, a device will always look for the tower with the strongest signal. Sometimes that happens to be the closest tower. But if there's too much interference, a spike in usage concentration, or even just bad weather, the best connection might be a tower several miles away, despite many being closer.
Now, I want to talk about your conclusion in this case. Is all this methodology considered reliable in your field?
Absolutely. It's the same methodology I teach students.
Did you apply it reliably in this case?
I did.
And was all the data you reviewed sufficient for you to reach a conclusion?
Yes, ma'am.
Did you reach a conclusion to a reasonable degree of scientific certainty?
I did.
What did you conclude?
I concluded that the location data provided for Alex Callahan's device could not possibly be used to determine her exact location on November 17, 2025.
Would it help explain your conclusion if we used a cell tower map of the area?
It would.
Your Honor, may Dr. Santiago leave the witness stand to use an enlargement of what has been entered as Exhibit F?
Yes, she may.
Your Honor, may I move to see the annotations?
Yes, go ahead.
Dr. Santiago, what are we looking at here in Exhibit F?
This is a cell tower map of downtown Valdivia that the TBI investigator prepared.
Using Exhibit F, can you explain why Alex Callahan's phone location could not be determined from the cell tower location data?
Sure. The first problem, right on the map, are the fact that there are 3 towers, all within several blocks of each other, all in a busy downtown area with a spike in usage concentration.
The coverage area of these towers all greatly overlap each other. It was intended that way by the phone carrier to ensure that there's always reliable signal. But that means when it comes to determining precise location, it is pretty much unusable, even at a normal time.
You say at a normal time. Was November 17th, 2025 between 9:15 and 10:15 p.m. a normal time?
It wasn't. There was a soccer game that bled out at this stadium just a few blocks away. The soccer game bled out at about 9:15 p.m. So at this point, you have got potentially thousands of people who all start using their devices at pretty much the same time. That in turn would have caused an increased load on the towers, meaning each of their devices are being constantly handed off to towers one after the other, possibly even every couple minutes.
And what can Alex Callahan's phone records tell us about her location at 9:55 p.m.?
Really nothing. The records show 2 system pings, one here at 12:13 and again at 12:22, both occurring within seconds of each other, which tells us exactly what we'd expect to see in a downtown area with overlapping coverage. The towers appear to be handing off the device, not due to distance, but signal strength.
Now, Dr. Santiago, we heard Dr. Waldo say that the remaining time records after 9:55 p.m. that evening show the device continuing to register at Tower 1222, which Dr. Waldo believes indicates the device was moving east toward Luxford Financial. What do you say about that?
That doesn't make scientific sense. Sure, it would be one thing if we had 5 or 10 additional towers moving further and further east over a long period of time. But we're talking about one tower handoff, not even the furthest east tower, at only one point in time, in a busy downtown area with a slight usage concentration. The data just doesn't support that conclusion.
And what about the fact that Dr. Waldo says the phone was, quote, within walking distance of the restaurant at 9:55 p.m., the time of the shooting?
It's just not possible to make that leap. This limited data set, with its already problematic conditions, tells us that Alex Callahan's device was probably somewhere on this map between 9:15 and 10:15. Beyond that, the data doesn't reveal Alex Callahan's location any more reliably than throwing a dart at the map.
Thank you, Dr. Santiago. I have no further questions, Ron.
Please. Cross-examination.
Go ahead.
Oh.
Good evening, Dr. Santiago.
Good evening.
I'd like to talk about the conclusion you just made for the jury. So, if a cell phone is outside of tower's coverage range, it would not connect to that cell phone tower, correct?
That is very much true. Yes.
Then I'd like to look at these 2 towers and their coverage ranges that you drew. Neither of these 2 towers' coverage ranges include Luxford Financial, correct?
I'm sorry, I can barely see it from this view.
Neither of these 2 coverage radii that you drew include Luxford Financial, correct?
Yes, sir. And I see what you're saying there. I actually meant to draw the circles around all of Luxford Financial and La Scala.
Then, Dr. Santiago, I'd like to move on and talk a little bit about your credentials. You prepared a curriculum vitae for today's trial, correct?
That is correct.
This curriculum vitae is a record of your business,
Yes, it's a resume.
and you keep it regularly updated.
Yes.
I'm showing opposing counsel a copy of Exhibit K. May I approach the witness?
You may.
And would Your Honor like a copy?
I would. Thank you. Thank you.
Dr. Santiago, this is your curriculum vitae, correct?
That is correct.
Your Honor, at this time, the state offers Exhibit K into evidence. Its authenticity has been stipulated.
Any objection?
No objection, Your Honor.
Okay.
In that
Admitted?
case, may I set up a demonstration for the jury?
Yes, you may.
Do you mind if I move this? Leave this. I didn't choose that. Sorry. Dr. Santiago, I'd like to start by talking about the summary of your skill set at the top. This summary describes you as a computer scientist, correct?
That is correct.
Yet nowhere in this summary, does it mention cellular triangulation?
No, it does not, but that is a part of the study of computer science.
Moving on, you have 3 degrees in computer science, correct?
That is correct.
And none of them mention cellular triangulation?
No, just like none of them mention multi-path propagation or network load balancing. I wouldn't specifically put that in my resume because it falls under the studies of telecommunications and computer science.
Dr. Santiago, this curriculum vitae contains all of your relevant skills and experience, correct?
That is correct.
All of your relevant skills and experience to this trial, correct?
That is correct. Yes, it's
Yet
resume.
nowhere in this entire document do you mention that you have any skill, education, experience, or training with cellular triangulation. Is that correct?
Not specifically triangulation, no.
Yet today you testified that you could not use cellular triangulation to pinpoint the defendant's phone's location, correct?
That is correct. And it's under telecommunications.
Then I'd like to talk about why you might have come to that conclusion. Because you're being paid $10,000 to be here today, correct?
That is correct.
But this isn't your standard rate, is it?
No, it's not my standard rate. I'm discounting Ms. Callahan.
You're discounting Ms. Callahan because you've known the defendant, correct?
Yes, from a networking group several years ago.
The defendant put you in touch with some silent business partners?
Yes, with a car wash business.
The defendant also put you in touch with a lawyer?
Correct. I reached out to a networking group. Ms. Callahan is the one who reached out.
Dr. Santiago, if this phone was connected to Wi-Fi, would any of these cellular detail records exist?
Yes, it doesn't matter if a device is connected to Wi-Fi or not. The device will still signal to cell towers.
You're telling the members of the jury that when a phone is connected to Wi-Fi, it's also connecting to cell towers?
Yes, sir.
Thank you, Your Honor. Thank you, Dr. Santiago. Nothing further at this time.
Thank you. Any redirect?
No redirect, Your Honor.
Okay. You may step down, Dr. Santiago.
May the defense call its next witness.
You may. Go
The
ahead.
defense calls Mr. Ellis Klein to the stand. Before we proceed, may I ask two enlargements facing away from the jury?
Facing away from the jury?
Yes, Your Honor.
Any objection?
No objections.
Okay, go ahead.
Yes, sorry. May I proceed, Your Honor?
You may. Go ahead.
Please tell us your name.
Good evening. My name is Ellis Grossestein Wolfgang Schuven von Klein.
Mr. Klein, where are you from?
Currently, I live here in Bella Vita, but as you can extrapolate, I am not from here.
Where is it you're from?
Also clients are from Deutschland, or as you all would call it, Germany.
Well, what brings you here to the U.S.?
Right now, I am a full-time exchange student at Bella Vita University. It has been lovely, aside from the money. In America, the scholarships exist. In Germany, they work.
Do you have a job?
Yes, I have a part-time job as a security technician to supplement the meager funds I get from the school.
Where do you work as a security technician?
Downtown at Bella Vita Laboratory Solutions. My job consists of patrolling the building for a few hours, manning the security cameras, and then I get a 15-minute break.
Were you working the night of November 17, 2025?
Yes, I was.
Did you follow your typical working process that night? The one you just described to us?
At first, yes. I clocked in around 7:30, patrolled the building for 2 hours and 10 minutes, and then I took my break at 9:40. That's when I tried to take my nap.
What do you mean you tried to take a nap?
At 9:40, I went out to the loading docks to lie down for a quick power nap like usual. But about 2 seconds after I laid down and closed my eyes, I was woken up by 2 loud bangs.
Did you know what this sound was?
No, sir, not at the time. I couldn't tell whether it was gunshots or fireworks or something else American. But of course, later I did learn it was gunshots.
What did you do when you heard these 2 gunshots?
I immediately jumped up and started looking around to see where the sound came from.
When you started looking around, what did you see?
Not a lot, it was very dark, but I did see a person walking out of the alley of La Scala Ristorante, a local Italian place. It looked like they were wearing a long coat and a reddish-orange scarf.
Could you tell which direction this figure was walking in?
Now that I could tell for sure. They were walking east on Whitlock Street.
Your Honor, may Mr. Klein join me in the well to use this enlargement, which has already been entered into evidence?
Any objection?
No objections, Your Honor, but may I reposition myself?
May.
May I publish to the jury?
Sure.
Thank you, Your Honor. Mr. Klein? Mr. Klein, using this map of the downtown area, and of course this marker, can you show us specifically where you saw this figure walking?
Yes, I saw them walking this way directly. My apologies.
We have more markers, Mr. Klein. 1 second. Try the green one.
Thank you.
Of course.
I saw them walking this way up Whitlock Street.
Mr. Klein, at any point that night, did you see the figure walking here toward where Luxford Financial is, along this street, represented by the Luxford Financial being the blue dot? Were they walking on that street at any point?
No, sir. The only time I saw them walking was this way up Whitlock Street.
Thank you, Mr. Klein. You may take your seat. Mr. Klein, after you saw this person in the alleyway, what did you do?
Well, by that point, I still wasn't exactly sure what I had done. So I ran back to my post in the lab to put up the security footage.
And what did the security footage show you?
Not much. I went through the moment just before I heard the shooting, and I saw a still image of the shooter. Our system is very old, and the cameras are like to freeze up all the time, and that happened right after the shooting.
What did you do next?
By that point, the police had arrived on the scene, so I went over to talk to them. I spoke with Detective Ellis, who asked if I would be willing to come down to the station with him to answer a couple of questions about his investigation. I said yes, so I rode over with him in his patrol car.
Let's talk about your meeting with Detective Paris. How did it begin?
It started fairly normally, I suppose. He asked those standard questions, like, where I was at the time of the
Objection,
murder.
Your Honor. Relevance. This witness is about to testify about their conversation with Detective Paris. Detective Paris is not a witness we have called in this case, and therefore the quality of his investigation is not relevant. We are not using that investigation in court today. Rather, we are presenting the jury with a series of facts that they can evaluate themselves.
May I respond?
You may.
Now, relevant evidence is any evidence, or any evidence that has any tendency to make a fact of consequence more or less likely. Just because opposing counsel has decided not to call the Detective Paris for whatever reason, doesn't mean this witness is not allowed to testify to his experience with the detective. This is going to show that the detective conducted a faulty investigation, therefore is incredibly relevant to this case as Miss Callahan is being attacked, convicted by the detective.
Any response?
Your Honor, if I may, how Ms. Callahan got to trial today is not relevant. She's in trial now, and it's up to the jury to decide whether or not she's guilty. But Detective Paris is not in court today, so impeaching the quality of his investigation is not relevant to this case.
Briefly.
I'm not impeaching the quality of the, I'm not impeaching anything. I am showing this was a faulty investigation. But aside from this, the witness is allowed to testify as to what pertained in his witness statement. And what pertained in his witness statement is what he experienced previously to this trial. And that is relevant to the trial, because relevant evidence is evidence that has any tendency to make a fact of consequence more or less likely. A very low bar.
Your objection is overruled. I'm going to allow the question.
Yes, Your Honor.
Mr. Gonzalez, I'm going to re-ask my question. How did your meeting with Detective Paris begin?
Like I said, it started normally. He asked where I was at the time of the murder, what I was doing, and whether I had
Objection,
seen
Your
it.
Honor. Hearsay. This witness is testifying about a statement that Detective Paris made, and then that is an out-of-court statement being used to prove the truth of the matter asserted.
a response?
Yes, Your Honor. Under the hearsay definition 801, a hearsay is an out-of-court statement offered in court for the truth of the matter asserted. Now, if you go to subsection A, it defines what a statement is. A statement is a written or verbal assertion. Now, this witness is testifying to a question Detective Harris asked. Now, to be clear, if I were to say that this table's brown, that is a verbal assertion. If I were to ask, is this table brown? It's not asserting anything, it's asking something. Therefore, questions are not pertaining to the hearsay definition.
Your Honor, Detective Paris's question in this scenario implies a statement. It implies that Detective Paris believes the statement he is questioning to be true. And therefore, I believe it is still hearsay and inadmissible.
May I respond, Your Honor?
Briefly.
The detective's question implies nothing about the answer. He's asking you a very general and basic question about what did he do, what did he see, what process did he follow. There is no answer suggested or asserted in the question.
Any response?
Your Honor, I believe this witness will go on to testify about continue to testify about Detective Paris's questioning in this case, and I believe that further line of questioning is inadmissible.
Is there any hearsay exception that applies if this is hearsay?
The further line of questioning, we can't really address it yet because we don't know what the testimony will be, and therefore we don't know which exceptions will apply. When it arises, I'd be more than happy to address those hearsay exceptions at the time. I think the right moment.
I'm going to overrule your objection with respect to this question, and then you are welcome to renew the objection with additional testimony.
Yes, Your Honor. Mr. Gonzalez, once more, I'm going to re-ask my question. How did your meeting with Detective Paris begin?
Well, he talked to me fairly normally, as the questions you would expect. 5 hours at the time of the murder, what I was doing, and whether I had seen anything. And I told him that I saw a person walking out of the alley of La Scala and walking up Whitlock Street.
How did the detective react when you told him this?
His demeanor changed. He began to look very excited, cheerful almost.
Objection, Your Honor, speculation. This witness is speculating about Detective Paris's mental state, that he looked excited. This witness has no personal knowledge of how Detective Paris was feeling.
May I respond, Your Honor?
You may.
Opposing counsel just testified to the fact that this witness is testifying himself to the mental state of the detective. Then she went on to say that this witness tonight is testifying to the way he looked. Now, mental state cannot be seen. That's exactly what I'm proving. The witness is able to testify as to the physical appearance of the detective, and that physical appearance was giddy, happy, joyful. This is not speculation. There's nothing to speculate. He was a witness.
Your Honor, if I may, if this witness wants to talk about Detective Paris's facial expressions or any actions he took, that would not be speculation. But speculating that he looked excited implies that he was able to read Detective Paris's facial expressions and understand what he was thinking, which is speculation.
Your objection is sustained in part. The witness may testify as to his observations, physical, observations of the detective's kind of physical appearance, physical reactions, but we're going to keep the testimony to that.
Of course, Your Honor. Mr. Gonzalez, what did you see the detective do after you told her this?
Well, after I asked the detective, or the detective asked me this, he began to look very, just more excited than he was before. Before then he was nonchalant, I think you would say. And after that, he perked up. He looked more interested.
What did you do when the detective responded in this way?
I tried to tell the detective I did not get a good look at this person. But that is when the detective pulled out a picture from his coat pocket and set it on the table in front of me.
Who is it a picture of?
It was of Alex Callahan, although I did not know this at the time.
Did the detective ever explain to you why he was walking around with a photo of Alex Callahan in his coat pocket?
No, and I didn't ask.
What did the detective do after he pulled out the photo?
The detective asked if this was the person I had seen in the alley after the shooting.
What did you tell him?
I gave the picture a good look, but I told the detective I did not think it was the same person.
What did the detective do once you told him this?
His demeanor changed again.
What do you mean?
Well, snatched a picture back and started pacing the room, back and forth, head pointed at the ground, muttering to himself.
When the detective started pacing the room, muttering to himself, what did you do?
To be honest, I started to get a little freaked out. I was just about to ask if I was free to go, but that's when the detective turned back in my direction and swiped the coffee mug off the table.
What do you mean, swiped a coffee mug off of a table?
I mean, he turned back to me with this really aggressive look in his face and swiped his coffee mug right off the table. It hit the floor and shattered, and the coffee spilled everywhere.
Mr. Gonzalez, would you recognize a picture of this napkin? If I showed it to you?
Yes, I would.
May I approach the witness? Well, I'm approaching the witness. I'm first showing opposing counsel what has been marked as Exhibit J. Mr. Gonzalez, I'm handing you a napkin. What has been marked as Exhibit J? Your Honor, would you like to comment?
I would,
May I
thank you.
approach?
You may.
Mr. Gonzalez, what is this I've just handed to you?
This is a picture of the broken mug I took the night that the detective smashed it.
Is it a fair and accurate copy of the mug you saw?
It is.
What did the detective do after he swiped the mug off the table?
He went to go get some napkins to clean up the mess he made, tried to play it off as an accident. It was no accident.
Objection, Your Honor, speculation. Again, this witness is speculating that Detective Paris smashing this coffee mug was not an accident. As he is not Detective Paris, he has no idea what Detective Paris may have been thinking, and therefore cannot speculate on his mental state.
Your Honor, this is not, may I respond?
You may.
The witness does not have to testify to the mental state of the detective. As far as he knows, based on his rationally based perception, the detective, with an angry look at his face, turned back and intentionally, as he perceived it, swiped the mug off the table. He is allowed to testify to what he rationally perceives, and this is admissible, and it is not speculation.
Your Honor, if I may, this witness, again, intentionality is something that only the person doing the action can be aware of. So this witness is speculating to Detective Paris's mental state that he smashed the mug intentionally when he just testified that Detective Paris was saying that it was an accident. He's also, furthermore, he's speculating that Detective Paris tried to play it off as an accident, which would, again, be a mental state.
Your objection is overruled. The witness is allowed to testify about his perception of what transpired.
Yes, Your Honor. Although we do not have enlargement, may I publish to the jury this first? As this has been properly identified by the witness, I'd like to offer Exhibit J in evidence.
Any objection?
Yes, Your Honor, to relevance. I don't see, this witness has just described the coffee mug being broken. I don't see how providing a copy of the photo of the broken coffee mug is relevant to this case or would make any of the facts of consequence more or less likely.
May I respond, Your Honor?
Briefly, go
Relevant
ahead.
evidence is evidence that has any tendency to make a fact of consequence more or less likely. If the detective were to walk like this and brush the mug off the table, it may have chipped. There may have been a crack. We have proven, and we will show, that the detective intentionally swiped the mug off the table. If he intentionally did it, if he did it with force, the mug would appear differently than that if he had slid it off. If there was force behind his movement, this will show and will be shown through the mug. This is incredibly relevant. It moves the bar of relevance.
Any response?
Your Honor, this witness has already testified that he believes that Detective Harris smashed this mug intentionally. Furthermore, I don't agree with counsel's argument that swiping a coffee mug off a table would make it more or less likely to break significantly than throwing it down. That's an assertion that I'm not sure this witness has laid any foundation for. And I still don't see how an image of a broken coffee mug in a trash can with only some shards showing and paper towels in it would make any of the facts of consequence more or less likely.
I think this meets the low bar of relevance, so I'm going to allow the exhibit. It's admitted.
Yes, Your Honor. May I publish to the jury?
You may.
Now, when the detective came back, did he ask you any further questions?
No, sir. He told me I was free to go, and I got out of there as fast as possible.
At any point during your interview with Detective Paris, did he ask you any questions about any other potential suspects in this case?
No, sir. Callahan was the only one.
No further questions, Your Honor.
Thank you.
Cross-examination, Your Honor?
Go ahead.
Would you like me to take that?
Yes, please.
Good evening.
Good night.
You heard Dr. Waldo testify earlier?
Yes, I did.
You heard her say that that the defendant's phone was traveling east up Whitlock Street?
Yes, that is true.
That's the same direction you saw the person. That's the same direction you saw the person fleeing the crime scene going?
Yes, ma'am, that is correct.
Then I'd like to talk about your work. Now, you're a full-time student at Bella Vita University?
Yes, I am.
And you also work the night shift at your job?
Unfortunately, yes. It was the only job I could find.
You find it difficult to balance both school and work?
Yes, ma'am, that is true.
So you started taking naps during your shift?
No, ma'am, not during my shift. This is during the breaks I am allowed by the company. I take a 10-minute power nap just to give myself a quick burst of energy to get through the night.
Let's move to the 17th. Now, that evening you were desperate for sleep, weren't you?
Yes, ma'am. I had been up all night the previous night because my dog kept me up with his barking. His name is Augustin.
So you went to take your nap early?
Yes, at about 9:40.
And then you were awoken, as you testified earlier, by gunshots?
Yes, I was.
You could make out a figure in the corner of your eye fleeing the alley.
Yes, ma'am. I got a good look.
Now, to clarify for the jury, it was really dark, wasn't it?
It was pretty dark in the alley, yes.
And your eyes were blurry?
For a moment, yes.
But you could have made out that this figure was wearing a long coat.
Yes.
And an orange scarf.
That is correct.
Let's move on. Now, your job has a comprehensive security system.
Yes, ma'am, it does.
This includes security cameras.
It does.
And they recorded footage of the night Mr. Malone was murdered.
Yes, ma'am, that is true.
But then, the footage was deleted.
Yes, ma'am. Unfortunately, the system, as I said, is very old. And the cameras, they often delete footage because they need automatic updates. And that is what happened with the footage of the shooter.
It's your testimony today that your job's security system deleted footage the same night it was taken because of an automatic update?
Yes, that is what happens most of the time. The footage was corrupted.
To be clear, this footage was corrupted before anyone other than you saw it.
Unfortunately, yes.
Then I want to talk about why you might be saying that, because a couple of weeks after the incident occurred, a few men who said they knew Miss Callahan came by your work.
Yes, ma'am, that is true. They wanted to know if I knew anything that could help Miss Callahan. They seemed to have a very heartfelt concern for their friend. I could relate with that, and I told them that I did not see much.
I'm not asking you whether or not they cared for Miss Callahan, but is that a yes to my question? They did come by your work specifically.
Yes, ma'am.
And they told you they hate to see her go to jail.
Yes, ma'am. As any good friend would, I would not want any of my friends to go to prison, and that is what I could tell from these men.
And they only left after you told them that you didn't see anything.
Yes, ma'am. We had a brief discussion, and I said I did not see it.
Now, to be clear for the jury, you couldn't say for certain whether or not the figure you saw in the alley was Miss Callahan.
Yes, it is true.
But it did kind of look like her, didn't it?
I want to be completely clear on what I did and did not see. I gave the picture a good look, but I told the detective I did not think it was the same person that I saw in the act. It maybe sort of looks like whoever I saw, but I do not think it was them.
Mr. Klein, I'm not asking you about what you told Detective Paris. To be clear, the person you saw in the alley did kind of look like Miss Callahan, the defendant.
Like I said, maybe it looks like them. Yes.
Thank you, Your Honor. No further questions.
Thank you. Have any redirect?
No redirect, Your Honor.
Okay, you may step down. Ready for our final witness?
Yes, Your Honor. The defense calls Alex Callahan to the stand. Please tell us your name.
My name is Alexandra Callahan.
Mr. Ms. Callahan, have you been listening here today as these prosecutors have accused you of murdering Johnny Malone?
I've been listening.
Ms. Callahan, I want you to look these jurors in the eye and tell them, did you murder Johnny Malone?
I did not murder Johnny Malone.
Were you in any way involved in the death of Mr. Johnny Malone?
No, absolutely not.
All right, before we talk more about Mr. Malone, I'd like to let the jury get to know you. Where do you work?
I work for an investment firm. It's called Luxford Financial.
What do you do for Luxford?
I'm a senior financial analyst, which means I help people grow and manage their money.
How did you get started in finance?
I sort of fell backwards into it. It was just me and my mom growing up, so we didn't have a lot of money, and I learned the importance of family budgeting very early on. I sort of naturally fell in love with it, so I put myself through college, and Luxford took a chance on me shortly after graduation.
As a financial analyst, what involvement do you have with new businesses?
It's common for startup businesses to seek funding from investment firms like Luxford Financial. So I'm the first point of contact for businesses like that to assess whether they would be a good fit for our company and whether or not I can recommend an investment either for a repayable loan or ownership interest.
Is that how you met Johnny Malone?
Yes, it is.
Could you explain to this jury how exactly you met Mr. Malone?
Mr. Malone approached Luxford asking for investing in his company called Canine Kind. It was a product line of dog toys that were filled with a digestible filler.
Did Luxford invest in Mr. Malone's business?
Yes, I recommended a moderate investment and the team agreed to do it.
How did Mr. Malone's company perform?
At first, very well. His sales skyrocketed as soon as he launched.
I noticed you said at first. Did his company's performance change?
Yes, ma'am. After a while, I began noticing very suspicious transfers of money into foreign accounts. And Mr. Malone was extremely evasive about that anytime I asked him.
Was that the end of your concerns with Mr. Malone's business?
No. Things got worse as veterinary reports came out that the digestible filler was actually toxic to cats. A local paper wrote a story about this that claimed Mr. Malone knew about this prior to product launch and tried to cover it up.
After these reports came out, what happened to his business?
It essentially collapsed overnight.
Did you ever attempt to speak with Mr. Malone about this?
Yes, many times. He did not pick up my calls.
Were you ever able to get a hold of him?
Eventually, I knew that he liked dinner at La Scala, and I stopped by one day. He was there, and I sat down to talk.
Tell us about that conversation.
It really wasn't much of a conversation.
What do you mean?
At this point, we were in a precarious position, and I told Johnny exactly that. I said, look, I'm so sorry things have worked out this way, but we have to work together to wind things down professionally. He just sat there and didn't say anything.
All right, now I want to talk about November 17th, 2025. Where were you that day?
I was slammed at work. That was the night that the Quarter 3 performance reports were due.
Ms. Callahan, at any point on November 17th, did you go into the La Scala restaurant?
Never, at any point.
When did you learn that Mr. Malone had been killed?
The next morning on the news.
At any point did you speak to law enforcement?
Yes, Detective Paris contacted me and asked me to come down to the station for an interview. I immediately agreed and came the next morning.
At what point did you realize law enforcement suspected you were the shooter?
Pretty much immediately as I met with Detective Paris before he even started asking me any questions.
Tell us about your meeting with Detective Paris.
I told him, look, tell me what you want me to show you or provide or tell you that proves I didn't do this. But he became very aggressive.
What happened then?
I again answered any questions that he had, but he became more aggressive, wouldn't let me finish, kept jumping on top of my answers, and eventually he just looked at me and he said, Miss Callahan, you
are going down for this murder.
Objection, Your Honor. This is hearsay. This witness just testified that Detective Harris told her that she's going down for murder. This is an out-of-court statement being used to prove the truth of the matter asserted. Pursuant to Rule 802, that evidence is his.
Your Honor, may I respond?
You may.
Your Honor, for this to be hearsay, opposing counsel is right. It would have to be offered for the truth of the matter asserted. Now, the specific statement by Detective Riley Paris is, Ms. Callahan, you are going down for this murder. As the defense, of course, we are not offering this evidence to prove the truth of that statement, that Alex Callahan is going down for this murder. It is our job to acquit her.
Your Honor, if I may, it sounds like opposing counsel is using this evidence as the effect on the listener, which would be an exception to the hearsay. However, if opposing counsel is going down this road, then that would mean that this statement, it doesn't matter whether or not it's true or not. However, that is not the case. It really does matter if Detective Paris meant what they were saying, if that statement was true from the declarant. That is why it's hearsay.
Are you relying on the effect on the listener exception, hearsay exception?
Your Honor, we're not offering this evidence to prove its effect on the listener. Instead, we're offering it to show the bias and lack of credibility in Detective Paris's, their lead homicide investigator's investigation.
Your Honor, if I may, if they're using this to show the bias in Detective Paris's investigation, then I'd like to switch my objection to relevance. We have not offered Detective Paris in this trial. The investigation's credibility is not in question, and again, does not make Ms. Callahan's guilt more or less likely in this case.
Your Honor, may I respond to the relevance objection?
Briefly.
Your Honor, Detective Riley Paris is the reason that my client is sitting on the witness stand today. If it wasn't for Detective Riley Paris's investigation, Alex Callahan would not have been charged with murder. For that reason, it is incredibly relevant that we are allowed to ask any questions about the reliability of their lead homicide investigator's investigation. That's why it's relevant, and Your Honor, I would still continue to suggest that it is not hearsay because we're not offering it for the truth of the matter asserted, we're offering it to show that lack of credibility.
I'm going to sustain the objection on hearsay grounds.
Yes, Your Honor.
Your Honor, then I ask you to strike that testimony that Detective Harris' statement.
We will strike the testimony. Thank you.
Yes, Your Honor. And now, Ms. Callahan, is there any part of this investigation that you were not compliant with or would not have been compliant with?
Absolutely not. I was compliant with everything that Detective Harris asked of me and would have continued to do so if that led into my GPS location or offering surveillance footage from my place of work before he decided I was going down for murder.
Thank you, Ms. Callahan. Your Honor, I have no further questions.
Thank you.
Your Honor, before I begin, may I set up a demonstrative that will be turned around in 10 seconds?
You may.
Hello, Ms. Callahan. I'd like to talk about your sponsorship of Mr. Malone's business proposal. In October 2025, reports came out about the product you investigated, right?
Yes, that's correct.
They claimed that Mr. Malone had concealed test reports.
Yes, that's what it claims.
That was shocking to you, right?
Absolutely. If I had any idea that Mr. Malone was hiding safety testing, I would have never invested in his, or recommended investing in his company.
Right, you would have invested because you didn't even know about this information all along, right?
Yes, absolutely not.
Being a compliance officer, you decided to press Mr. Malone about these issues, right?
Yes, absolutely.
But he wouldn't give you a straight answer, would he?
No.
He instead claimed that you had known about this all along.
Yes, that is what he accused me of, which is completely ridiculous.
But Ms. Callahan, you've worked in the financial sector for over a decade, right?
Yes, sir, that's correct.
You take great pride in your work.
Absolutely.
You wouldn't just turn a blind eye to this, right?
No, absolutely not.
So it was frustrating when Mr. Malone disrespected your sponsorship.
Yes, it was frustrating that he deceived me and the entirety of Wexford Financial.
So you would even say that your relationship with Mr. Malone was openly adversarial, right?
Yes, in a professional sense, we were adversarial.
You decided that you needed to meet up with Mr. Malone to finally hash things out, right?
Yes, to wind things down professionally before I took this to executive management or even our legal team.
Right, and you met with Mr. Malone at La Scala Restaurante, right?
Yes, that's correct.
The very same restaurant where Mr. Malone was killed just a few weeks later.
Yes, sir, I believe that's correct.
During this meeting, you kept you were antagonizing. You kept asking Mr. Malone about these reports, right?
Absolutely. I reiterated what I had been confronting him about months prior.
But he just wouldn't give up answers, would he?
No, he didn't actually say anything at all.
At the end of this meeting, you scribbled an angry note and threw it at him, right?
Yes, I was frustrated, but I did not throw anything at Mr. Malone. That's extremely unprofessional.
Well, you gave it to him. You gave it to him. He has it, right?
Yes, sir.
Well, you recognize a copy of this note?
Absolutely.
Your Honor, let the record reflect that I'm showing opposing counsel has been previously marked as Exhibit B. Your Honor, may I approach the witness?
You may.
Would you like a copy?
I would. Thank you.
Ms. Callahan, is this a fair and accurate copy of the note that you wrote?
Yes, sir, it is.
Your Honor, at this point, we'd like to enter Exhibit B into evidence its authenticity has been stipulated.
Any objection?
No objection, Your Honor.
Okay, the exhibit's admitted.
May I flip around my demonstrative?
You may.
And may I additionally publish copies to the jury?
Yes.
May I move to the demonstrative?
Yes, of course.
Ms. Callahan, this note says last chance. See you soon. Right?
Yes, absolutely. And it was Mr. Malone's last chance to wind things down like professionals, and I hope to see him soon at our office.
Now, I'd like to talk about where you were on the night of the murder. You claim that you were in your office the whole time, right?
Absolutely.
You were working on your Q3 financial reports?
That's correct.
You had your phone on you the whole time, right?
I tried to stay off my phone at work, but it wasn't my place of work.
Yeah, absolutely. And one of the colleagues that was with you at that time was Tony Quinn, correct?
Yes, I saw Tony Quinn in the office multiple times that night, but we didn't work closely together.
Isn't it true, Ms. Callahan, that you gave Tony Quinn $2,000, correct?
Yes, absolutely. A gift after he had an extremely hard financial time over the holidays.
Ms. Callahan, the question wasn't why you gave the gift, it's just a yes or no, you did give him the gift.
Oh, absolutely. Yes, I did.
And Mr. Quinn hasn't paid you back for this, right?
No, I didn't intend it as a loan. It was a gift.
In fact, you told the office to not tell anyone about it, right?
I told him to not mention it to our coworkers to make me seem overly emotional as I am their boss.
That's a yes that you told your office to not tell anyone about it.
No, I told Tony Quinn not to mention it to our coworkers or anybody in the building.
Right. And Tony Quinn isn't in the courtroom today, are they?
That's correct.
So the only person that can tell this jury where you were at the time of the murder is you, correct, Ms. Callahan?
I believe that's correct.
Thank you. No further questions, Your Honor.
Any redirect?
Nothing further to this witness, Your Honor.
Okay. You may step down.
Thank you.
Could you please take this now? Yeah.
Closing arguments, Your Honor.
You may proceed.
May I set up one additional demonstrative?
Yes.
And additionally, Your Honor, may I reserve up to 1 minute of my remaining time after closing for rebuttal?
You may.
You've put us in a precarious position. Last chance. See you soon. Members of the jury, those aren't my words. They're the words of the defendant just 3 weeks before Mr. Malone was killed. That's simply not the kind of thing you say to a client. That's what you say to someone when you've stopped seeing them as a person and started seeing them as a liability. And that's why the defendant is on trial today for first-degree murder. Now, as the judge will tell you, the definition of first-degree murder doesn't mean that we had to prove to you that the defendant had a motive to kill Mr. Malone. It simply means that we had to prove to you that the defendant intentionally and deliberately took Mr. Malone's life. That's exactly what we proved to you here today. And we did it by focusing on the same 3 key facts that my co-counsel, Mr. Dunn, told you we would at the beginning of this trial. The sponsorship, the scarf, and the signal. We started with the sponsorship because even though we had no burden to prove a motive for you today, we did so anyway. The defendant sponsored Mr. Malone's business, and that business went underwater. To tell you about this, we called Mr. Rory Branigan. Mr. Branigan has no dog in this fight, and he has no reason to lie to you. Mr. Branigan told you that just 2 weeks before the murder, the defendant was talking about this bad business deal. He told you that the defendant was on the warpath about this bad business deal. But that's not all that Mr. Branigan told you, because he also told you about a note. This note, found on the victim's car, written on paper from the defendant's place of work. It says, "You better make this right, or else." But you didn't just have to take Mr. Branigan's word for it, because then we called Mr. Sky Gonzalez. Mr. Gonzalez is a waiter at the La Scala Ristorante. Mr. Gonzalez told you that just 3 weeks before the murder, he saw the defendant and the victim having dinner together. He told you that at this dinner, the two got into a heated argument, and the defendant scribbled something on a note, crumpled it up, and threw it at Mr. Malone. He then showed you that note. It says, "Last chance. See you soon." But that wasn't all that Mr. Gonzalez told you about, because he also told you about the second key fact of this case, the scarf. He told you that when the defendant left that dinner, he left behind a distinctive orange scarf. He then told you that he was working the night of the murder, and that just after the shots were fired, a busboy yelled, "Someone in an orange scarf is running down the alley." Finally, members of the jury, the third key fact, the signal. Today we called Dr. Lee Waldo, an expert in telecommunications and cellular triangulation, whose conclusion was with professional certainty that the defendant's phone was at the scene of the crime at the time of the crime. Additionally, Dr. Waldo's testimony was consistent to the very movement with the defense's own eyewitness. Members of the jury, today the defendant had a constitutional right to not testify today, and she waived that right. But members of the jury, that was a mistake. 3 simple pieces of testimony from this trial prove that the defendant lied to you. 1, the defendant testified that she had her phone with her the entire time she was in the office. 2, Dr. Waldo testified that none of these cell detail records would exist if the defendant's phone was connected to Wi-Fi or on her person. 3, the defendant testified that she never left her office. The defendant lied to you today. The sponsorship, the scarf, and the signal prove that the defendant intentionally and deliberately took Mr. Malone's life. And that is why I'm asking you to find the defendant guilty of first-degree murder. Thank you.
Your Honor, before I begin my closing argument, may I retrieve a copy of Exhibit J from the witness stand?
You may.
Oh, yes. Oh, answer my phone.
Imagine you dump out a 1,000-piece jigsaw puzzle onto a table. Only before you can ever look at the pieces, someone hands you the box lid. But it's the lid to the wrong box. So now for every piece you pick up, you try forcing it to match that picture. Some pieces clearly don't work, others maybe could, So you turn them around sideways, force them in, get rid of the pieces that don't work, and focus on the ones that maybe sort of do. After a few hours of effort, you're left with a picture that vaguely resembles the picture that you saw in the box. Only it's not the right picture, it's the picture you thought was correct. It's exactly what happened in this case. The government decided on the picture before they ever looked at the pieces. They decided first, and they investigated second. Now, before I go any further, I want to make one thing clear. It's never been our responsibility to prove that the government mishandled their investigation. It was their responsibility to prove they didn't. It was their burden to prove that Alex Callahan was guilty of murder beyond a reasonable doubt. And they failed. So let's walk through that. First, consider the state's lead homicide detective. The only reason Alex Callahan is sitting in this courtroom today. Detective Paris did not take the stand to testify about his investigation. Detective Paris isn't even in this courthouse. The only reason you know their lead homicide investigator's name is because we told it to you. What could Detective Paris be so ashamed of about this investigation? Let's walk through that. First, we know that the moment he began interviewing witnesses, he already had a photo of Alex Callahan in his coat pocket. Then what does he do with that photo and the only eyewitness in this entire case? How about show that photo along with 5 or 6 other individuals to see if the eyewitness can give a positive photo ID? Nope. Not Detective Paris. The government had already decided who was guilty. So then, is it any real surprise that when the eyewitness gave the answer they didn't want, that doesn't really look like the person I saw, they then continued shopping around for someone to pin this on Ms. Callahan. Their digital forensic expert, although she would only admit this to you after being read it off of her own statement, initially concluded that there was only a decent probability and likelihood that Alex Callahan's phone was in the downtown area. Detective Riley Paris saw this and had a talk with that expert. Members of the jury, we know exactly how that conversation went because it resulted in a complete shift of the expert's conclusion and a new career advancement. Finally, let's do something that the government wouldn't do and look at this case big picture. We have a woman with a career in finance. And sure, her firm loses money on a business deal. But her reaction is, oh, I better go commit a murder. How am I going to do it? Well, let me walk 10 blocks down a crowded city street to the back parking lot of a busy restaurant, hope no one sees me, fire off 2 shots, then walk back to my office, hope there's no security camera footage to catch me up along the way. Members of the jury, that story is not just reasonable doubt, it's ludicrous. A real investigation asks who did this. This one asked how do we prove it was her? And once that question changed, everything else changed with it. It was no longer finding information for the truth. It was forcing facts to fit a theory. And our system simply demands better than that. They decided first and investigated second. But today, you are the safeguard against that mistake. And in this case, the law does not call for compromise. It demands courage. It demands a verdict of not guilty. Find the defendant not guilty. Thank you.
Your Honor, may I have a time check before I begin rebuttal?
I have 42 seconds, but I was gonna. I'll just flip it to 30 when it gets up.
Your Honor, may I proceed?
You may. Go ahead.
Members of the jury, today the defense told you that we would decide first and investigate second. The defense told you that we would present you with an investigation and that that investigation would be faulty. But members of the jury, quite frankly, that just isn't the case. Instead of presenting you with an investigation, we presented you with a series of facts. We decided to let you, the members of the jury, perform this investigation yourselves throughout the duration of this trial, and then make that decision. Members of the jury, now is the time to decide, and I'm asking you to decide the only decision that makes sense. Find the defendant guilty of first-degree murder. Thank you.
Okay. Believe we are ready for the jury to retire for deliberations. The jury has already been instructed on the relevant law. We will take a recess.
All right.
Thank you. I'm Sarah Campbell. I have the privilege of serving on the Tennessee Supreme Court, one of 5 members on that court. I want to just begin by congratulating all of you. Phenomenal. I judged this competition 4 years ago. This is my second time judging the final round, and this tournament is special to me because when I judged the final round 4 years ago, it was actually my first time being in a robe on the bench because I had just been confirmed to my court, and we hadn't had oral arguments yet. So yeah, it was my first time on the bench. So it's fun to be back here 4 years later, and. I was so impressed 4 years ago that I insisted that one of my sons can't come today. So if you didn't notice, I had a very helpful assistant judge with me this evening, Carter, who's melting into his seat right now. He's in 3rd grade, so we don't currently have mock trial at the elementary school level, but maybe we need to change that. So I am really delighted that he had an opportunity to see you all and something to aspire to. For sure. You all were truly amazing. I echo the jurors over here in wishing that the lawyers that appeared before me were consistently as good as you all were this evening. I mean, we have some exceptional attorneys, don't get me wrong, but you all really, at your age, to be as poised as you are, as competent as you are, the evidentiary objections really were amazing. And I'm an appellate judge, not a trial judge. So I usually get a lot of time to think about evidentiary issues, unlike my trial judge colleagues over here. So you kept me on my toes too. And, what I love about mock trial, I'm not going to take too long because we have the votes in. So I'm going to wrap up quickly. But what I really love about mock trial is both that it gives you the opportunity to improve your public speaking, to develop the kind of poise that I've seen here tonight, but it also gives you an opportunity to get a glimpse into the justice system and to really begin to understand courts and what we do and why we do it and why we have the many protections that we do. Whether it's a civil case or a criminal case. So I really applaud you for putting in all of the effort that was needed for you to be here tonight. I applaud your families, the parents, and I see some siblings, I think, back there too. So great job, siblings, coming to support your brothers and sisters. Congratulations, and it is such a privilege to get to do this, so thank you for letting me be part of this. And thank you to our TBA, Young Lawyers Division, who works tirelessly to put this on every year. It's such a service to our profession, it's such a service to these teams. So thank you all for what you do and for being here this evening and all weekend. With that, I get to announce the winner. Okay, drum roll, please. The winner of tonight's competition is the defense.